All right, well, let's begin. Thank you everyone for joining us. We'll give folks a minute here to hop into our Zoom chat. At the meantime, I think I'll cover a little bit of housekeeping. Most folks who've been doing this now for the last couple of years might be familiar with this. So it shouldn't come as too much of a surprise on a housekeeping level how this will go. My name is Matt Germer. I am a fellow in the governance program at the R Street Institute. R Street, for those who are unaware, is a think tank focused primarily on promoting free markets and limited effective government. That includes an effective judiciary. Specifically, we believe that an independent and robust judiciary is the cornerstone of our democracy. But in recent years, we've seen a fracturing of our political norms, leading to an increased cynicism of the judiciary's role in our government. My approach, at least when it comes to research on the judiciary, is to identify positive reforms while also cautioning against attempts to politicize or undermine the judiciary for political gain. And that leads us to our conversation today about court reform, and that includes things like packing the court, term limits, ethical standards, and more. For those folks, as they join our call today, if they're interested in the subjects that they're hearing about, I encourage you to look up each of our panelists and investigate their work, as well as to check R Street's website at rstreet.org. There, if you work your way to my page, you'll find a paper released over the last couple months providing a bit of analysis on many of these topics. We will be taking some questions today in the chat. There should be a Q&A box available for you to submit questions. We'll do our best to address those questions at the end of our conversation. That said, we are also going to do our best to end on time today at 1 p.m. Eastern. I know that there are some folks both in our panel and viewing us today who have some interest in checking out some low-key congressional hearings that begin in about an hour. And maybe you have to get back to work. Either way, we'll try to be respectful of your time. So with that, I don't want to spend too much more time on housekeeping and background. Instead, I'd like to introduce the panel today. And today with us, we have three thoughtful voices in the world of the Supreme Court to help us navigate this question of court reform. First, I'll introduce Adam White. Adam is a senior fellow at the American Enterprise Institute's program on social, cultural, and constitutional studies. He co-directs the George Mason University's C. Boyden Gray Center for the Study of the Administrative State. And importantly to this topic, last year he served on President Biden's commission on the Supreme Court. Next, we have Sarah Isker. Sarah is a staff writer at the Dispatch, where she writes a weekly elections newsletter called The Sweep, and she co-hosts the Dispatch podcast, as well as the site's flagship podcast, Advisory Opinions. Prior to the Dispatch, Sarah served in the Department of Justice, and she served as legal counsel and an advisor for a number of political campaigns. And then finally, we have Gabe Roth. Gabe is the executive director of Fix the Court, which is a nonpartisan organization that advocates for court reforms that are designed to make the judiciary more open and more accountable to the American people. Prior to Fix the Court, Gabe managed the Coalition for Court Transparency, where he advocated for broadcasting Supreme Court proceedings, and before that worked in political consulting. So with that, let's jump right into our discussion, beginning with, I guess, a little bit of background on the subject matter. And Adam, I'm wondering, as a member of the Supreme Court Commission yourself, you were in the room where it happened. If you can start us off by explaining at a high level what the commission was, why it convened, and in your eyes, whether you felt like the commission was effective.
Well, sure, glad to. And thanks for inviting me. Many thanks to R Street for organizing this conversation. The Court Commission, its formal title was the Presidential Commission on the Supreme Court of the United States, was instituted by President Biden shortly after his inauguration to make good on a campaign promise shortly before the last presidential election that he would organize a commission to study the possibility of expanding the court and other possible reforms. He appointed me among many others. There was 36 people. Who doesn't love a group project? And I was a vocal critic of court packing or court expansion before the commission was instituted. And so I was grateful for the opportunity to serve, given my sort of oppositional viewpoint to at least some of my colleagues on the commission. We focused over the course of a year on court expansion, but also on other issues, including the ones we're discussing today. Term limits, the process of judicial review, the relationship between Congress and judicial review, and then also some related issues. But mostly people were focused in the public on the court packing issue and on term limits. We issued a drafts of chapters from the report in, I think, October of last year. We concluded our service in December, issuing a report that, as our mandates indicated, explored the issues but did not set out any recommendations. And I felt very pleased with the outcome of the process. I thought we did a good job. There's a lot of things in the report that I would have written differently or disagreed with altogether, but I think it actually, I'm very proud of our work and grateful for the opportunity to do it.
Great, and thank you for that background, because I think that helps to provide a little bit of common understanding for our viewers. I'm not sure everyone here is necessarily a Supreme Court reform advocate or follows these issues closely. But with that in mind, let's jump right into some of those topics that were covered. And Adam, I'll keep it with you here to start off. You know, really the elephant in the room for the commission's creation and the reason why, as I understood, you know, Democratic nominee or candidates were kind of hustling each other on this issue, and Joe Biden ultimately made good on his promise to create a commission, was around adding members to the court, or as you know, known as court packing. And it was one of the major topics investigated by the commission. If you can start us off here with your thoughts on court packing. You mentioned that you were a bit of a critic of the idea. Where do you see it? And I guess now as well, it's been 6 or 7 months since the commission ended. The Supreme Court is once again thrust into the national spotlight. Have your views on this changed at all?
The court packing issue really emerged about partway through President Trump's term in office. It wasn't so much in the aftermath of the Gorsuch appointment, which followed the Senate giving the silent treatment to the Garland nomination. It really followed Justice Kennedy's retirement, maybe a surprise retirement, the appointment of Kavanaugh, and then all the more so after the unfortunate passing of Justice Ginsburg, followed by the very swift and speedy confirmation of Justice Amy Coney Barrett. You saw more and more calls on the political left to pack the court, and often they use those terms. Court packing had been sort of an infamy ever since FDR tried it in the 1930s, but you saw sort of explicit calls to pack the court. I was instinctually against it from the start for a couple of reasons. One is just, it's hard for me to imagine opening the door to court packing without opening the door to further rounds of court packing. I don't think there'll ever be court packing once and for all. And I think that once it's normalized, what we'll see is the court growing more and more until it really resembles less a court and more a legislature. Second, I don't know that 9 is the perfect number. Maybe 7 would have been better. Maybe 11 would have been better. I don't know. But I think experience has taught us, dating back to the mid-19th centuries, since we've had 9 justices on the court, and this is all set by statute, not by the Constitution. 9 justices seems pretty well suited to get a large court that isn't too large to actually hear and decide cases. And my central or animating principle throughout my work on the commission was what best positions the court to do its job, which is to hear and decide cases. So that's an issue where I arrived at the court with a fairly firm view. And to be honest, I found the discussions enlightening. I learned a lot about the history. It didn't change my mind. Another subject we might get to later, term limits, is a related issue where I actually did arrive with one viewpoint and left with another.
Great, thanks. So Gabe, I'm going to call on you next, or Sarah, I guess if you have something to add. I'm going to call Gabe though first real quick, just to say, I know you've got a lot of other things in your court reform world. Is this one of them? You know, is adding justices to the court valuable? We have 11 circuit courts. We've got a couple additional, DC and federal circuits. Does it make sense to line up the number of justices with the number of appellate circuits, make them ride circuit? These kind of ideas. Where do you fall down on this issue?
Personally, I don't love the idea of expanding the court, but I would be okay with a temporary expansion of the court as we get to term limits. In other words, I helped write and I'm a supporter of a bill that is currently in the House called the Supreme Court Term Limits and Regular Appointments Act, HR 5140, and it would start adding 18-year term limited justices upon enactment. So if it passed this year, next year, there would be an 18-year term limited justice that would be appointed in 2023. And so that justice would be the 10th justice, because the way the bill is currently written, it doesn't imagine kicking the most senior justice, Clarence Thomas, off the court. There are other proposals that would immediately push Justice Thomas into senior status. No bills have been introduced in Congress. There have been a few drafts that I've seen kicking around that might be introduced later this year. But currently, the way I believe we need to get to term limits is immediately. And if that means temporarily, there are more than 9 justices, because I have questions as to the constitutionality of changing the office while somebody is in that office, i.e., kicking Thomas off after 31 years without his volition. In 2025, you'd be kicking Roberts off after 20 years. I don't know if that's necessarily constitutional. So I like, fix the court has always been in favor of 18-year term limits. This is an idea that we take a lot from Steve Calabrese's seminal article and work from Carrington and Cramden and Akhil Amar. So a whole cross spectrum of ideologies sort of coalesced around 18-year term limits about 20 years ago. But the problem with their plan was they were going to say they were going to institute the 18-year term limits like 20 or 30 years down the line. I don't think we have time to wait. So I want to do it right away. And if that temporarily means there being more than 9 justices as we sort of reach this equilibrium, I'm okay with that, because I think it's better than the other options of, like I said, waiting 30 years until all the current justices are off the court. Or another idea is, adding another justice, but then waiting, that 18-year term limit starts like right away, but then they only start serving once like Justice Thomas leaves the court. So if Thomas stays another 10 years, then the next justice would only serve 8 out of those 18 years. I don't like that either. So temporary expansion, yes. Permanent expansion, no. 18-year term limits, yes.
Sarah, I'll move it to you. And actually, I think there's a particular part of this you might be able to offer some feedback on as well, which is perhaps the political ramifications of expanding the court.
Yeah, so I was very term limit curious going into the Supreme Court Commission's work, and I listened to all of their public hearings. I mean, I really nerded out over this stuff and had a great time. So thank you, Adam, and the others. And I was term limit curious because I think that there is something arbitrary and potentially corrosive when, through dumb luck, one party's presidents get to pick all of the Supreme Court justices. Imagine that it was all 9 for a second. I don't think that's helpful to sort of a pluralistic society and self-government. Here's the problem. I believe that Gabe's idea is the best idea, but that what would end up happening is that you would have presidents basically run on who their Supreme Court nominees would be. The first time we ever had a Supreme Court nominee list, of course, is when Donald Trump ran in 2016. He put out a list when he was a candidate. He didn't pick from that first list. He put out multiple lists over time. Gorsuch ends up being on list 2 or 3. Adam might remember better than me, but I know he wasn't on list 1. And what I don't think we want is presidents saying, here are my 2 picks for when I'm running, if I win. And I think what you would have sort of evolutionarily in politics in 10, 15 years from when that happens is Supreme Court justices then running with their presidential candidate, being part of the ticket. Like the vice president, you would have 2 Supreme Court picks, that would stump every year. I think that is more corrosive than the arbitrary problem that we have now. I'm not liking either one, but as the term limit thing sort of comes to a head, you have to pick. Do you want Supreme Court justices sitting at, Trump rallies or Biden rallies or whatever else? Or do you let chance work out, in which case, yep, right now there's some arbitrariness in 6 Republican nominees, but chance tells us that it'll actually work out the other way. And at some point there will be 6 Democratic nominees. I think that's the better route.
So to follow up on that, Gabe, I want to bring it back to you for a minute. And we've heard some criticisms of term limits already, I guess, in the course of this conversation. But some of the other ones, just to kind of put into your mind and get your response to, would be that justices might game their retirement and say, I want to leave early to make sure that someone that I agree with can replace me. You might see kind of similar to what Sarah's saying, a further politicization of the court. And I know that there's maybe already some discussion and a lot of cynicism out there that the court has already been politicized. Do you have any thoughts on that? Is it a valid concern for term limit folks or term limit skeptics? And is it addressed in your legislation that you put together?
Yes, I have thoughts. All the bad shit's already happening, right? I knew who Hillary's nominees were going to be. I knew who Trump's nominees were going to be, give her, plus or minus, a 0.001 percentage point on the Martin Quinn scale, which, says how political you are as a justice. I know who Cory Booker's nominees would be. I know who Ron DeSantis's nominees would be. It's not difficult to figure that out. And if you look at the design of the Constitution, it's kind of crazy that it's only until now that presidents are running, with who their justices are going to be. It's justices are political. It's constitutionally political because the president picks and the Senate confirms. So the idea that we've had like 200 years of, I don't know, stasis, which we really haven't, but let's just pretend for a second, because that's what, common pretending is, that we've had this 200-year stasis of, oh, judges are above politics and they're neutral. No, I mean, if we read the Constitution, you would expect the justices to be just as political as the people running for president. So I think that's already happening, and it doesn't, bother me that that's it doesn't. What surprises me that it's the past that seems apolitical, and now we're in this new partisan future. So I'm not worried about it. But I think that that's where things are going already. And so, things are only going to get worse, as Sarah alluded to. So we might as well try to figure out solutions that reduce the power of the court, which is, I think this is part of why we're talking about this, is because the court has become so powerful and we need to find solutions to that. I think term limits is part of that conversation. But overall, I really, just looking at the last 5 years of what's happened to the court, I don't think you can get more political than that. And to Sarah's point, if they show up at a Biden rally or a Trump rally, like, they're all current sitting lower court judges. So if they do that, you can file a complaint against them and you can move to remove them from office. So like, there are things in place that I think that if it goes, it's already pretty close to the edge, but if it does go over the edge, there are backstops to try to prevent that.
Adam, you said your views have evolved on this.
Yeah, and if I maybe try to pile on a little bit here, but my sort of concerns come from a slightly different approach than Sarah's, and just off the bat, I want to agree that there's a number of good reasons for term limits as I saw it coming onto it. One, life tenure incentivizes now younger and younger judges, and I'm curious what the limiting principle of this is, whether we'll someday see 35-year-old justices or something. The founders, just as a medical reality, never envisioned justices in the ordinary course of business serving 50 years on the court. And I agree that the phenomenon of timed retirements is very, very problematic. Frankly, I like it better when conservative judges time their retirements than progressive judges, but I also can see it's no way to run a country. So these are all big problems. And I came to the commission's work sort of favorably inclined towards term limits. But then the more I saw sort of the practical side of this and how it would work in practice, the more skeptical I began, excuse me, because I can't see a way that 18-year term limits would work without significantly reducing the Senate's role in the confirmation process. And that was actually my original point of entry for the issue almost 20 years ago now. When I was in law school, I wrote a law review article during the Bush years when the Senate was blocking his lower court nominees. I wrote an article arguing that the Senate did not have an obligation to vote or even to act on a judicial nomination, that it was incumbent on the president to bring the Senate in his direction. Like most law review articles, nobody cared or read it until about 5 seconds after Justice Scalia died, and then it became relevant. But I believe this all along, that the Senate's role in the confirmation process is extremely important. But if we install 18-year term limits, either we will have a system where the Senate can hold open seats open indefinitely and really incentivize more of the Senate just blocking judicial nominees until they retake the Senate. Or, and this is what I've seen in all the proposals, you have to water down the Senate's role, basically limit the amount of resistance the Senate can put up to any judicial nomination. And after maybe rejecting a couple of nominees, basically take it out of the Senate's hands. I think that would be a terrible structure. I think it's very important for the Senate to have this role. And frankly, in this day and age, I think one of the greatest problems is too little power in Congress, too much power in the presidency. And so I think term limits would inadvertently shift even more power to the presidency. And like Sarah, then I also am just worried about the basic mentality of this. I understand that we already think of the Supreme Court's possible vacancies as tied up in presidential elections. I don't think that's a good feature of our politics. But mapping Supreme Court vacancies onto the presidential election cycle, and that's what 18-year terms would do, two vacancies for every 4-year presidential term, we really are treating those vacancies as almost a spoil of the presidency on a regular schedule. I joked during one of the commission hearings, we'd be treating seats on the Supreme Court like couches in the Oval Office. 2 new ones are delivered after every inauguration. And so I'm in favor of reforms that, beyond just this one issue of the Supreme Court, that empower Congress and sort of push back against the slow growth of the presidency. And I see this as part of that.
So then I guess I'll open this to any of you who might have a thought. Is one of the answers less a limit on how long you serve and instead a mandatory retirement age or senior status age? And I guess I ask as someone who is, in my mid-30s, maybe I've now peaked. I can no longer be on the court as I've hit that threshold. As soon as you become eligible to run for president, it's too late to be on the court. But does a retirement age work? Would it help to serve at least, if not the same function, its own function of making sure that you've got folks who have perhaps more connection to, modern technology. We've seen cases that turned on understandings of what TikTok are, and we can only assume going into the future that those kinds of issues will continue to pop up in the court. Does a retirement age help?
Well, so one of the cases this came up with recently was the angry cheerleader case, as I've dubbed it, or many have dubbed it. And this involves Snapchat. And there were some whispers of Justice Breyer's clerks having to really explain the inner workings of Snapchat to him, which is always a fun mental image to think about. Mandatory retirement age certainly has a lot of things going for it, though. What's interesting is that we've seen more the need for mandatory retirement in some of the other branches than we have in the Supreme Court. There haven't actually been a lot of discussions of Supreme Court justices not being mentally up to the job. I think you're right. There's a certain question of, do you modern technology, or are you like hip with the kids or something? But if anything, you would expect to see that play out in the elected branches and the more accountable branches, that if voters really cared about that and thought that their elected politicians were out of touch, they would vote for younger people, when in fact, we have an incredibly old cohort of leadership in Congress. And of course, our last presidential election was 2 old dudes, is the technical scientific term for that. So I don't see a reason to have mandatory retirement age that is different than Gabe's very good reasons for having term limits, for instance. I also think that there's equally good reasons to have minimum ages for the Supreme Court. We have minimum ages for the House, the Senate, and the presidency. And as Adam mentioned, the age of justices is falling. At the point that you graduate your 3rd year of law school, go to a clerkship, and then go to the Supreme Court, maybe we should think about that too. But again, I think you actually run into the same exact problems that you do with term limits without some of the benefits. So I really do think that Gabe's point and arguments are the best arguments. It's a relatively close call, but in the end, I'd probably vote against them. But I still like his better than all the alternatives.
So if we can turn then to a bit of a different subject, unless there's any closing thoughts on court composition and tenure, I want to ask about some of the other topics that were raised in the Supreme Court Commission report. Turning first to transparency on the court. It became, I think, a hobby for a lot of court watchers in the last few years to go from reading the transcripts to now that with COVID protocols putting in live audio, it's for a real small slice of legal nerds, like the highlight of the week to tune into oral argument. Is that enough? Should we be putting cameras in as well to provide more Americans with kind of just a reason to tune in and watch? Is it good TV from is it enriching perspective versus, are there concerns then of it becoming more fodder for clickbait and for cable news hits and the rest? And I guess this really sticks out to me, and I will credit Sarah with this for her analysis of, I believe it was the Coach Kennedy oral advocacy case that one of the advocates there, I would say, may not have put forward the client's best interest at all times. And it might have hinted toward a future where performative advocacy might take over. So Sarah, I'll start with you because you are the one who introduced me to this topic. How do you fall on cameras in the court, and is live audio a good addition? Should it stay, or is that the kind of thing that should fade away as pandemic restrictions fall off?
So let's start with sort of the principles here of transparency, which we all, for some reason, we kind of hold this out as good. Transparency is always good. So more transparency is always good. And Jonah Goldberg, who is our editor-in-chief of the Dispatch, has written on this, and we published a piece for National Constitution Center, which includes an argument about why transparency has actually been kind of bad for our democracy. You want transparency in outcome, what your government is doing, what they're spending your money on, but transparency in process has actually turned out to be really corrosive. Again, look at Congress. If you can't negotiate anything except in public, then you're not going to negotiate anything, which is actually what we've seen. So apply that to the Supreme Court. They're not negotiating in public. And let's set aside the leaked Dobbs draft for a second. When it comes to oral arguments, the question is that closer to process or is it closer to outcome? I think that's a hard question because I think the audio has been really, really great. You used to have to wait until the end of the week, and that was really annoying. And it was very limiting in terms of who could get into the Supreme Court. I am now a member of the Supreme Court bar, but when I was a law student, I had to camp out overnight in order to watch the arguments in the 2008 Heller gun case. And I ended up falling asleep in the court because I had slept so poorly in the rain without a tent because you couldn't bring anything with you. It really undermined any transparency point in that. So I'm all for making that branch more publicly accessible. I think cameras in the courtroom will have a terrible effect, even regardless. Look at the Amber Heard trial. That was not great. All these people on Twitter having feelings when they didn't know the law, about who they liked more, and it turning into a popularity contest. You mentioned the Coach Kennedy argument where one of the advocates really seemed to not be interested in persuading the justices who might disagree with his client's point ideologically, scoffing audibly at one point at Justice Thomas. Again, I think if you imagine that on camera and you thought you'd already lost your case. Now, remember, if the Supreme Court takes your case last term, for instance, you had an 81% chance of losing if you had won below. So, 81% chance you tell your client, look, we're going to lose this at the Supreme Court. Let's make hay while the sun shines and turn it into a circus. That's going to be a lot more able to do that if you can create snippets for TikTok, for cable news, for the nightly news. Than we have now. You're not really seeing much of that because it is only audio. In fairness, I think we're probably headed not towards cameras, but towards those sort of performative arguments at some point anyway. But I'd like to delay it as long as possible.
Gabe, I'd like to bring this over to you then. I know you've worked for years on court transparency. I assume that the addition of live audio has been a great addition in your mind. Is that enough? Or should we be taking the next step into video feeds as well?
It has been a great addition, and I hope it is made permanent. Right now, we don't know if it's just a pandemic era change or if it's going to continue into the next term at the Supreme Court. That announcement has not been made. So hopefully it's forthcoming. Look, I think Sarah makes a lot of good points, and I think two of her points I think should be taken in context, right? The Supreme Court is not Congress. It's not a legislative body. The justices are not running for office. They're not trying to get on MSNBC or Fox News or C-SPAN to use a clip of something they say in a House floor or a committee hearing in a campaign ad. And the Supreme Court is not conducting trials. I didn't watch the Johnny Depp Amber Heard trial, but I heard that it happened via SNL. And so, I know that it was poorly managed by the judge, just like so many public trials have been, unfortunately, and really set the cameras in the courtroom movement back. But because the Supreme Court only does appellate arguments, each argument is typically an hour, maybe with live audio, it's a little bit, 80 minutes instead of 60, maybe 90. It's a single day, right? People always ask me when I go to visit the Supreme Court, oh, what are you doing for the next day? Because I say, I'm not a lawyer. I'm not a member of the bar. I have to stand in line at 5 a.m. with all the plebes. What do you do the next day? I'm like, what are you talking about? There is no next day. I think since I started this job, no, I don't even think there has been a next day. I think the most recent next day was for the Obamacare cases, I think, if I remember correctly. And that was 10 years ago before I started this job. So
If I
Point
could just
is,
interrupt, we should clearly get Gabe credentials so that he also is not waiting outside.
Thank
I
you,
just want to
yes.
say, as someone who also camped in the rain, that this is no way to run a railroad. So on this, we hugely agree. It needs to be more publicly accessible.
I'm going
Yeah.
to say on behalf of the plebes that none of you get credentials and you all have to
We all camp. Honestly, that actually is probably just as good an idea.
No,
Sorry, Gabe. I didn't mean to
no,
interrupt.
you're fine. It's like, yeah, it's 50 people. I mean, SCOTUS blog did a whole series on this and found it's about 50 people, and that's, you know, my reporting has found that as well. It's about 50 members of the public can hear an argument, which is just ridiculous in a nation of 330 million that only 50 people can watch it. I mean, there are 200 other people in the room, but they are friends of the justices, the clerks, friends of the clerks, members of Congress, friends of Congress. I mean, you know, members of the Supreme Court bar. So, you know, it's sad state of affairs that only 50 people can hear oral argument. But, you know, the justices have had a hot bench long before there was live audio. That, you know, Justice Scalia is often credited as being one of the people who made it such a hot bench. It was a little bit more staid. If you listen to oral arguments 30 or 40 years ago versus say 10 or 20 years ago, it was a little more staid then. So I think Sarah's right that we're on this trajectory of it being a little bit more chippy or chipper or jumpy or even performative. And to me, cameras really comes down to whether or not they're obtrusive and whether or not the people who are running the cameras, i.e. the justices and their assistants, have command of the room. And I think the justices would do a good job of managing the courtroom. I think, you know, Chief Justice Roberts, when his colleagues have come near to blows, or when the attorneys have spoken out of turn, he has really set the tone, sometimes with a joke, sometimes with a stern look, sometimes with a stern phrase, has been able to manage the courtroom. So I think any of the concerns that we might have about cameras in the courtroom can be tamped down by just the nature of the fact that it's an hour-long appellate argument. And because, though, yes, there are certain bomb throwers on the court, I think overall, the people who would be participating, namely the Supreme Court bar, the attorneys and the justices themselves, would want to comport themselves in an adult manner. So, you know, it would be, you know, it wouldn't be them who would be turning it into a circus, I don't think, yeah.
Great. Well, thank you. And I guess I'm going to ask Adam then a kind of a follow-up on some of this. First, for your thoughts on cameras in the courtroom more generally, but, you know, I guess I'll point out in prefacing this question, the number of state courts are broadcast via video and no one watches except extreme, you know, nerds who that's what they, yeah, exactly. And I'll say I've done it as well, but they're broadcast on the state version of C-SPAN. No one cares. And no one's really, I mean, this is in a number of states where justices are often elected on partisan elections. So really there's the incentive to taking those clips and using them, and no one is. So would it be different at the Supreme Court level? And if anything, would it perhaps even be a good thing, since you might be exposing more Americans to the actual law underneath the cases and the arguments being made that's actually being, you know, turning the decisions, as opposed to, you know, do you like the outcome or not? How do you fall on these issues?
That's very interesting. I hadn't thought about the state court connection, particularly in conjunction with the fact that a lot of state justices are elected. And so therefore you'd need to worry not just about showmanship by the lawyers, but also by the judges, the future candidates for re-election. I hadn't thought about that. And now it'll worry me. And frankly, the more that, to the extent that the Roberts Court channels more issues back to the states, as it did with Dobbs on the abortion issue, it'll be interesting to see what comes of these sort of sleepy state Supreme Court oral arguments when they're hearing the state level rows and so on. At risk of sounding like grumpy man yells at cloud, or old man yells at cloud, I mean, that's kind of where I am on this issue. I have some sympathy for, and actually, you know, I'm open to the idea that same day audio release was a good thing, but it's not clear to me that it actually was a good thing in terms of improving the public's understanding and awareness of what the justices are doing. I know it's been a boon for the journalists, no offense, Sarah, but you know, it gives us all something to argue about on Twitter the day of the big oral argument. It's very exciting. But honestly, the more exciting the Supreme Court gets, the more I get worried. And I don't think there was anything necessarily bad about an era when you could get transcripts, you know, pretty soon, especially with the internet, but you'd wait a few days for audio, and then C-SPAN would broadcast the audio with the photos of the justices. that seems like a good tempo for trying to understand the court's work. Begin with the journalists and sort of move outward a bit more slowly. So I frankly, I think the jury is still out on whether same-day audio has been good for the court. And I'd be very, very wary of video for all the reasons that were discussed. I'm worried about the advocates who have less of an institutional interest in the work of the court and who would have more to gain from a big event. And so if there were cameras in the courtroom, I would want some way to shield sort of the advocates, to minimize their sort of personal role. If we're focused on what the justices care about, then I'd want video to focus on the justices and minimize to the maximum extent possible the advocate's role. In some ways, I see this as analogous to the black robes. The whole reason why the Marshall Court, Chief Justice John Marshall instituted the black robes was to take down the sort of individualized personalities of the members of the court and take that aspect out of the court's work. And I worry that in a way, cameras are an undoing of that to the extent that they would help incentivize more personality-based work by the justices themselves and the advocates. Now, I agree that in the era of the hot bench, justices have become celebrities. Scalia, notorious RBG, and everybody else. I don't know that that's a great development either. Again, grumpy man yelling at the sky. But to the extent that cameras in the courtroom would feed the celebrity culture around justices or would feed the sort of accelerated hot takery around the Supreme Court, I'm just against it.
Fair enough.
I think it would absolutely, by the way, change who argues at the court. I think you'd see far more common, for instance, this term, we saw the Attorney General of Arizona argue a case before the Supreme Court because he's running for Senate in Arizona. And the argument was okay. It was not as strong as it could have been from a Supreme Court advocate. I think you'll see that, Ted Cruz, for instance, argue a case before the Supreme Court because at that point, if it's now far more about cameras, far more about that news clip you're going to get after, why would you send in, my husband argued the OSHA vaccine mandate case just for asterisks and biases that I may have. Why would you send in him versus a celebrity lawyer to argue that case? And I think that at some point then you get to the point where the arguments are no longer actually part of how any of this, they're not meant to be persuasive anymore. They're just part of the theater, similar to congressional debates, right? Even after you introduced cameras in Congress, there were still congressional debates for some number of years, but slowly but surely it killed congressional debates. I think the same thing would happen over time with the Supreme Court. And maybe that's okay in the sense that maybe the oral arguments don't make that big a difference right now anyway. It's mostly on the briefs. The oral arguments change some things on the margins, but us pretending that, this is all sort of this Roman, we're totally walking into the room open to persuasion from both sides isn't quite true either. So I am very still open to Gabe's arguments, but I'm just not quite there in terms of my concerns on where I think it would end up.
Yeah, I think that's actually you brought up something I'd never considered before, which is the idea that cases might be brought forward where litigants, maybe even themselves, would want to represent themselves pro se if they could. And I think of it in this circumstance, at least, Ted Cruz probably would have taken that opportunity for campaign finance reasons to be the guy making his own arguments in favor of that, especially if he viewed it as a slam dunk of sorts with the current court composition.
Or the alternative, if again, you think you're going to lose.
Right. I guess using the hook of campaign finance as a pivot to my next topic, I want to ask Gabe some questions about ethical standards and particularly around disclosure and whether or not we should see more justices recuse themselves from cases, the grounds for recusal. And maybe for the purpose of our audience, if you can do a little bit of background on what are the standards today, who enforces them, and do they have any teeth whatsoever, and should they be modified in any kind of meaningful way?
Yeah, it's not a great situation right now, to be honest, but it's also very difficult to change the current situation. So currently, if you're a Supreme Court justice and you do something that the public or Congress believes is ethically or morally or wrong or maybe even illegal, the only recourse or reprimand is the high bar of impeachment and removal. And no justice has been impeached and removed in U.S. history. About a dozen lower court judges have been for things like embezzlement. over the years, but hasn't happened at SCOTUS. Can't imagine it's going to happen at SCOTUS anytime soon. And there is a federal recusal statute, which gives reasons why a judge or justices have been included in the recusal statute for several decades now, why they shall disqualify themselves as the language from a case. It's financial entanglements, family involvement. They know material facts of the case. They participated in an earlier version of the case when they were elsewhere in government service, let's say. But it's somewhat subjective. I hate to say it. I mean, it's, the lawyers will say, oh, it's an objective principle, but it's not. It's not. It says the judge shall disqualify himself, when his impartiality might reasonably be questioned. What the hell does that mean, right? I mean, yeah, there's case law in there, but no one actually is recusing themselves because of that. That's the first section of the law, 28 455. 28 USC 455A, and then B has a list of stock ownership, family involvement, previous involvement. So it's super vague, and it's really just not up to the standards of where we are in modernity. And on top of that, for lower court judges, there's something called the Code of Conduct for U.S. judges, which is also super vague, but a little better. And it says things like, a judge should try to do whatever they can to uphold the integrity of their office, and judges should avoid the political activity. Well, what's a political activity? If I, go to a fundraiser for a third party organization that has a 501c3 and a 501c4 arm, is that political activity? So, there's a lot of gray area, unfortunately. And what my organization tries to do is talk about this gray area and say that, look, there are these things that judges and justices are doing, whether it be a reply all email praising, I don't know, dead conservative soldiers like one judge in the DC circuit did, or, overseeing an office that's in charge of defending the Obamacare law and then hearing every single Obamacare case. Again, both, you could make the argument in those two instances that Judge Silverman in the former and Justice Kagan in the latter might not have done anything wrong, because there's nothing in the federal recusal statute or the Code of Conduct for U.S. judges that talks about dead traitors or Obamacare. So, it doesn't really, so I think there just needs, frankly, more. This is where Congress, this is a vacuum. This is a vacuum of modernity and ethics and morality. And Congress needs to do more to step in and say, look, this in 2022, the recusal statute has really not been updated in like 50 years. And, before that, it was like 70, it's been a long ass time before any of us on this panel were born. The three of us were born in the 80s. Adam, you're the one who was born in the 70s. Sorry, buddy. It's been born way, and it was last updated in 72. So we just need to set up, if your wife is fomenting a coup, don't sit on any cases related to said coup, like basic things. So that's where Congress needs to step in, take its power back, and say, these are the things that, when done by a judge or justice, constitutes an ethics violation. And there are the problem, though, just to sort of put a finer point on it, is if a lower court judge does these things, there is something called the judicial, the JCDNA, the Judicial Conduct and Disability Act. And there's punishment. You can be publicly censured, privately censured, have cases removed from you, go to sensitivity training, et cetera, et cetera. You can't really do that for the justices. So the justices, really, their punishment comes in the public sphere, the public opinion. The Wall Street Journal and New York Times and Washington Post editorial pages is, granted, the current 9 don't feel any shame, but in a normal world, they would, and that would be enough for them to stop doing unethical things. So how to actually punish the justices, I don't really have a good answer for that, but at the very least, they should have a code of conduct that says, these are the behaviors that I will follow that make it so that the public thinks that we are moral and ethical. But the fact that they don't even have that is just unbelievably pathetic and inconsistent with every single other judge in the United States.
Adam, I want to turn to you, but first I just want to say for Gabe, that's a scathing statement about the new Justice Jackson. You're lumped her in with the 9. So, I'm just going to go ahead and put that out there.
Hey, Judge, she's on my list. I've got, go to fixthecourt.com. The first thing is a list of all the shitty things the judges have done ethically. Jackson's on the list. She's a registered Democrat as of last week. Judges and justices should not be registered with a political party. I don't care if you live in a place like I do. I live in New York or DC, where like the Democratic Party is the election. It says next to your name, Breyer, Kagan, Jackson, registered Democrat. It says next to your name. Well, it did Gorsuch. He moved and I don't have his registration, but it said again, you know, some of the conservative justices too. It shouldn't say that. Just register to vote. Go vote. Wonderful. Be a part of the civic life of your community, but don't register with a political party.
Ooh. Well, I feel
Wait,
like we're
what
opening
about-
a new Pandora's box here.
No, I'm really interested in this. What about for if you live in a place with a closed primary?
Right.
So it's, yeah, no, wait till the general. Sorry. Yeah. I think you,
I don't think that's crazy. Yeah, okay.
yeah, I just say wait till the general.
I think I'm down with that.
And also maybe fix the primary in that area. Maybe not
Well, yeah, that's a
just
whole
fixing
other
the
issue,
primary,
so-
but, you know.
Oh, I think
Yeah,
Gabe and I are in violent agreement on
Yeah.
Alaska's amazing system of nonpartisan primaries and ranked choice voting general
Oh.
election. Just a guess that Gabe and I like have little
Yes.
heart tattoos
For sure.
somewhere on us.
For sure. Love ranked choice.
Man,
We got
so
that.
I
The
feel like
mayor here. It's
before we
great.
I almost need to point out that my day job at R Street, I do a little judiciary research. I'm actually the elections fellow. So this really is my bread and butter. But I know that I could spend a whole nother hour on this subject matter. Instead, I want to try to stay focused on court reform. Adam, your thoughts on ethics and recusals. And I am curious too, like there seems to be a value in having 9, right? So do we have any concerns over cases where one or even more justices feel like they're in a position to recuse? Is the institution harmed, or does that actually benefit from that additional ethical standard?
Well, that's a big question. I think it's the right question to ask. I want to say right off the bat, listen, the 70s weren't great, but one thing I will never apologize for is being a Gen Xer rather than a millennial. So you kids have fun. But no, I'd say I share a lot of Gabe's concerns. I thought, his points were very well put and even-handed. This is an issue that transcends or ought to transcend partisan lines. And I'm very worried about some of the ethical issues around the judiciary as well. You saw this series, I think it was in the Wall Street Journal, sort of tracing a lot of the sort of financial conflicts of interest, often unintentional. And so I could see sort of straightforward metrics for justices and judges alike, at least for newly appointed ones. It gets messy when you start imposing new obligations on sitting judges and justices, especially related to their income. But I could see sort of requiring judges and justices to get out of active investments, or at least non sort of mutual fund investments, avoiding individual investments in particular companies. That doesn't quite get to the issues we're talking about here, the much more nebulous issues that Gabe is describing about people's connections to issues or to administrations. I worry about recusal because, Matthew, as you pointed out, recusal then brings the court down to 8 justices or maybe fewer in a given case. There's only one Supreme Court, and we do need it to ensure some uniformity in case law across the nation. The court's work is important. And so for me, I'm less worried about recusal and more worried about justices' sort of lack of restraint around subjects that put them in the ballpark of recusal debates. Now, recusal and judicial ethics can't be a matter of heckler's vetoes, where one person criticizes a justice who they conveniently would like to see off of a court in a given case. And I think the more that we focus on recusal and ethical standards aimed at recusal that are nebulous, the more we incentivize, again, a heckler's veto approach to recusal. This is one of those issues where I think it's really incumbent upon the legal community, especially the legal community, not politicians or political activists. And I work at an ideological think tank, so I'm not sure which line I'm on sometimes, but it's incumbent upon the legal community to really police these things and really be willing to criticize the justices when they step into dangerous territory. And I think it's incumbent upon the more politically minded or ideological among us to police our own on these issues and really criticize our own justices when they get in gray areas, because the goal should be not recusals, but justices steering clear of anything that might reasonably call into question their impartiality. Now, again, as Sarah mentioned earlier, we understand the justices, they come to these cases not with a totally blank slate often. They have preconceived ideas about the law. That's unavoidable. It's in our system. It's a good thing, I guess. But we should minimize in every other respect any sort of perception of bias or other sort of influence around the court. But I sadly don't have a better answer for this other than self-restraint by the justices themselves and a real sort of commitment to norms by those of us around the court.
Thanks. Sarah, I apologize. I'm not going to give you a full window here unless there's a very particular thing you want to add.
Very small. I think Gabe has the better argument here with one note that I would like him to spend some time thinking about. Not that he hasn't, he has, by the way. And that's the spouse issue. I am concerned as the spouse of a Supreme Court litigator, for instance, about how we think of judges' spouses and what they are and aren't allowed to do. So we had, for instance, on the Ninth Circuit, a famous liberal judge's spouse who was the head of the ACLU's California litigation division and filed an amicus brief, for instance. Does that judge need to recuse? Does the ACLU then not get to file amicus briefs in cases, even though they don't know who's going to be on the panel, even at that point? The same thing happened at the DC Circuit. A judge's spouse was, in fact, the national ACLU legal director. Same exact thing happened. Now, again, remember, the ACLU gets involved with the case before they know which judge is going to be on the panel. And so you end up impacting spouses' careers that are often going to be women, by the way, in ways that I have some concerns about moving forward. I think we can address it all. You don't want to allow the recusal system to let parties game who's going to be the judges on their panel, which people would love to do. Especially if you could knock out individual judges by hiring their spouse or not. I mean, Ruth Bader Ginsburg's daughter wrote a law review article, for instance, and that law review article was cited by one of the parties in a case. I think that'd be crazy to make her recuse because her daughter was cited in the brief for the case, because they're obviously, trying to game the system in that way. By the way, she voted for the side that cited her daughter. So people can say that's an ethical issue. I don't think that it is. So that's all to say, I think Gabe has the better part of the argument here. I think we need stronger ethical obligations, especially at the lower court, that are just more clear, frankly. And I actually think he's on to the exact solution at the Supreme Court. Write it down, make it clear. By the way, wildly agree with Adam on the divesting from individual stocks. Why in the world are judges owning individual stocks to begin with? And then fine, there's no punishment at the Supreme Court, but you're going to say they violated their ethical code. And I think that will carry weight. And that would be enough for me, at least, to start. And let's see how that goes.
Thanks. And actually, as you say all these things, I wish we had more time, because some random, I've never considered this before. What if we had voir dire for judges, right? You've got an entire panel to pick from. Maybe instead of needing all 9, each side gets to knock out one justice, right? Or at appellate level, you've got the entire appellate circuit to pick from. You knock out 2 or 3 each. I also wonder from that perspective too, would you learn anything about which justices are the ones often getting bumped? And does that teach other justices in the future how to behave?
It would literally always be the same judges getting picked or not, struck on the peremptory challenges on like the 5th and 9th Circuit, for instance. They would never hear cases again.
It'd be interesting because that also, it would shape incentives for who you pick to be on the court and all the rest as well, without necessarily removing them from their position or changing the court's composition or adding justice. But again, I don't know that we have time for that, because there is one more topic I want to make sure we cover with a little time left for question and answer. And that is the rising use of the emergency docket, or what's been dubbed the shadow docket. I know that this is a subject that wasn't touched upon by the commission, but was not really the main focus of the commission. But I'd like to start with Adam on this question. If you could briefly explain to folks what the shadow docket or emergency docket is, why it's gained attention, and what should we be thinking about this as court watchers?
This is an area too where my thinking shifted during my service on the commission. In a nutshell, the Supreme Court, like lower courts, has the power to grant injunctive relief, not just at the end of a case, but often while the case is in progress, in order to freeze a status quo until the end of litigation. Oftentimes preventing the enforcement of a statute or preventing the enforcement of a lower court's decision. This has become increasingly important in the Supreme Court. It's always been an issue around the death penalty, but now in cases we saw, seeking injunctions related to COVID-19 policies and so on, or abortion laws, actually, it's become increasingly prevalent. This is an area where my thinking changed. I didn't see as much of a problem around the so-called shadow docket when I joined the commission. But as I spent my time on the commission, defending the court in terms of its classic status as a neutral, sort of passive body that receives cases, hears them, deliberates on them slowly, and then decides them, The court's injunctive relief, it does seem in tension often with that classical conception of the court, not the end of the world, but as it becomes more prevalent, it's a bigger issue. And I really see the debates around the court's shadow docket as part and parcel of debates around the lower courts with nationwide injunctions, where you see courts swiftly called into action to make momentous decisions, often with nationwide effect, very quickly and energetically. And I would just add that my concerns around the shadow docket are related, I think, or they're related also to another issue I've been thinking about, the court's cert discretion. The more time I spent on the commission, the more worried I became about the fact that the court gets to pick its cases in ways that really do sort of create some political color around the court itself. And so I would be in favor of a reduction in the court's shadow docket, in addition to reduction of nationwide injunctions in lower courts. And also, I would like to see the court's discretion to choose its own cases significantly curtailed. I'd rather the courts hear cases out of duty and not out of choice.
Great. We only have a couple minutes left, so I want to ask the remaining two to keep that in mind. Sarah, I know this is an issue that has impacted you personally, and I'm wondering, for the purposes of solving the problem, is there a hybrid on the table? Can we see some level of oral argument and briefing in an emergency posture, or does that ruin too many Christmases?
So he's referring to the fact that because my husband argued the OSHA vaccine mandate case, they announced that they were taking that 2 weeks later, and they announced it the day before Christmas Eve, which meant Christmas Eve, Christmas Day, New Year's, and his birthday, which is January 2nd, were all gone for us. And you had to test negative for COVID. So we also couldn't have childcare. There were all sorts of drama around it. Even so, even understanding that very personal downside, absolutely, they should be hearing oral argument, having full briefing on all these shadow docket cases. I think it would be good for the court, both in terms of the work that they actually do and also good for the public's perception of the court. Wild plus 1,000 on the cert point that Adam made. The court should be hearing minimum three times as many cases as it's currently hearing. 66 cases on its merits docket with 217-page opinions. We don't need that. We need more cases getting decided. And instead, as he said, they're cherry picking these cases based on, sure, circuit splits, but also just things of national importance. Sometimes it's okay just to take a case and make a decision based on what's correct. And instead we have this gaming of, for instance, on qualified immunity, where they are not taking cases on qualified immunity, even though there's all sorts of problems at the lower courts on what should make qualified immunity. What does that clear and convincing standard even mean? It's been a disaster since 1973. Yes, lots more mandatory jurisdiction. I'm all for it. And of course, the mandatory jurisdiction in the Constitution for original matters should be there as well.
Thanks. So we've only got a couple minutes. I'm going to go ahead and say we're probably not going to get to the Q&A at this point. My apologies to folks. I tried to bake in your questions to my transitionary questions. Gabe, I'll give you an opportunity, I guess, to respond to this particular point on the shadow docket. But if you could bake it into perhaps a 60-second answer on what reform should even be the top priority at this point. As we talked about a variety of things. Is it term limits? Is it ethical reform? I mean, they're all on the table, but what's number one for you?
It's right now it's ethics. I would like to see John Roberts spend the summer in Maine writing an ethics code. I mean, I've started one myself that I could send him. It's a Google Doc, pretty shareable. So just, I'll email it to you, John, after the taping. But, that to me, I think at a time when there's less and less public trust in the Supreme Court for various reasons, at the very least, knowing that our 9 justices are doing their jobs in an ethical, moral, and character-driven way, I don't think it would necessarily change the view of the public on the court overnight, because frankly, it's the decisions that matter most. But there are ethical questions swirling, and I think that just needs to be nipped in the bud as a very first step into reclaiming the moral imprimatur that the court should have.
So Gabe got 60. Sarah and Adam, you'll each get 20 because we are where we are on the timing. If for any kind of last thoughts, or if you've got a single priority that sticks out to you.
I'll just say actually that I'm really grateful for the work that Gabe does. That you can disagree with a lot of Gabe's ideas, but thank God someone is sitting here and saying, hey, look, if you don't like the way things are, here's an option, And it's very easy to sit and criticize why those options may not work. But I just want to shout out that I think Gabe's being the one to offer the alternatives is really important.
Thank you. Appreciate that a lot.
And I'm just grateful for the opportunity to be here today, even with all you millennials.
Well, I'd like to thank you three for joining our panel. There was so much that we left off the table. Perhaps we can gather again at some future date and address a number of these issues. For our viewers, thank you for joining us today. The recording of this will be available for you to share with your friends and family and coworkers and loved ones, as it makes one of the best gifts you could give. If you have more interest in these topics, I encourage you to follow each of our panelists on whether it's on social media or professionally. Check their websites and be sure to check out our work at rstreet.org. Thank you all for joining us today.